Mauritania is a large developing island nation situated in the Indian Ocean that has recently embarked on an expedition to Antarctica via the Heard and McDonald Islands. Their mission is to explore and identify potential resettlement locations for its climate-displaced citizens. Both Australia and Mauritania are signatories to the 1945 United Nations Charter and Statute of the International Court of Justice, the 1959 Antarctic Treaty, and the 1982 Convention on the Law of the Sea, commonly known as the UNCLOS. Additionally, Australia is a party to other international agreements, including the 1972 Convention for the Conservation of Antarctic Seals, or CCAS, the 1980 Convention on the Conservation of Antarctic Living Marine Resources, or the CAMLAR, and the 1991 Protocol on Environmental Protection to the Antarctic Treaty, also known as the Madrid Protocol. These three treaties, with the Antarctic Treaty, form the Antarctic Treaty System. Australia also has obligations under the 1972 UN World Heritage Convention because Heard and McDonald Islands are designated World Heritage Sites in Australian external territory. Heard and McDonald Islands are located in the Southern Ocean, around 4,000 kilometres from Perth, and were declared Australian external territories in 1937 by the British, before being subsequently listed as World Heritage Sites in 1997 under Clause 8 and 9 of the World Heritage Convention. This is due to their outstanding universal value as pristine, undisturbed island ecosystems and being the only sub-Antarctic volcanically active islands. The Heard and McDonald Islands Act of 1953 places the islands as being administered under the laws of the Australian Capital Territory and subject to the current Heard Island and McDonald Islands Marine Reserve Management Plan. All activities on the islands require permits and for visitors to abide by codes of conduct. Nevertheless, Malaysian representatives recently spent 3 days on the islands where they undertook marine surveys, collected scientific data, and erected a small campsite. But there's absolutely no evidence of them ever applying for a permit, nor contacting the Australian government in any capacity to secure permission to undertake visits or scientific study within Australian external territory. Mauritania has also proposed an East Antarctic settlement that will rely on fishing for finfish to a distance of 200 nautical miles from the territorial sea baseline, and will also enforce Malaysian civil and criminal law against others within the immediate area of the coastal settlement. This correlates with the definition of a state's exclusive economic zone and territorial seas respectively, which are defined and governed under the relevant section of the UNCLOS. Should Mauritania settle in East Antarctica, they may declare their territorial sea and EEZ off the coast of East Antarctica. This would prevent Australia from exercising its jurisdiction in the region and require us to abide by the domestic laws of Mauritania. Mauritania would have sovereign rights to explore, use, conserve, and manage Antarctic natural resources within their EEZ, which would include finfish, oil, gas, and minerals. At the very least, Australia would be required to request permission to access the region of the Mauritanian state to undertake research and other activities. However, any such claim made by Mauritania on the Antarctic continent would go against Article 4 of the Antarctic Treaty, which effectively puts all land claims on hold for the benefit of mankind. This is the exact same reason why the region of East Antarctica, including the Casey and Davis research stations, is not a declared Australian external territory. The Antarctic Treaty establishes that Antarctica should be used for peaceful purposes only. Although the use of military personnel and equipment for the purposes of scientific research and other peaceful purposes is acceptable, there are prohibitions on the establishment of military bases and fortifications and on undertaking military maneuvers and weapons testing. The same treaty also prohibits nuclear explosions and the disposal of radioactive material in Antarctica. However, the use of nuclear-powered ships that utilize a controlled nuclear fission reaction to power the vessel are acceptable. In both these respects, Mauritania has not breached the Antarctic Treaty. However, the treaty does call for the exchange of information regarding scientific programs to ensure maximum economy and efficiency to occur, and requires that scientific results are freely exchanged and made freely available to all parties. Furthermore, the treaty requires that the state parties inform the expedition before they undertake it, as well as all stations and military presence they may have in Antarctica in advance. So in this regard, Mauritania has offended the Antarctic Treaty by failing to notify Australia and other parties of their proposed actions. The UNCLOS requires states to adopt measures for the conservation of living resources on the high seas. An exception exists for military and naval vessels that are owned and operated by the state on a non-commercial basis. However, the state is still required to adopt appropriate measures for the protection and preservation of the environment, so long as they do not impair the operations or capabilities of the vessel. CCAS, to which only Australia is a party, specifically addresses seal conservation with 5 species currently protected south of the 60-degree southern latitude. That said, sealing of those species can still occur within the provisions set forth by the Convention, as the parties can issue permits for the catching of seals for food, scientific research, or museum specimens. To issue a special permit, all parties would need to be notified of the purpose, intent, and outcomes. Permits would also need to consider the annex to the Convention, which applies to permissible catch, protected seasons, and closed seasons, amongst others. Furthermore, Mauritania is not a party to the CAMLA or the Madrid Protocol, so they are not required to abide by preservation and wildlife permit principles contained therein. Of these, Mauritania is only required to abide by the UNCLOS principles. In terms of fishing, Mauritania is required to abide by the relevant UNCLOS requirements. If Mauritania were to declare their EEZ, they would need to assess for the allowable catch limits of their living resources. This could include the Patagonian and Antarctic toolfish, which includes many populations already under stress and severely depleted. If Mauritania were to commence commercial fishing of these and other finfish species, Australia's commercial interests would suffer. Patagonian toothfish, for example, are a cross-boundary species which are managed by the CAMLA. However, Mauritania is not currently a signatory of the CAMLA, so must only abide by the UNCLOS requirement to collaborate and cooperate with Australia to ensure effective stock management. Further to this, Mauritania would be entitled to set their own catch limits in line with the UNCLOS if they declared jurisdiction in Antarctica. Although coastal states are required to promote optimum use of all living resources within the EEZ, there is no guarantee that Mauritania would abide by this requirement, or if they did, that their management would be effective as is Australia's current regime. Although the UNCLOS requires the utilisation of best scientific evidence to restore or maintain maximum sustainable yield for fishery species, Mauritania have fewer resources to do this when compared to Australia's developed economy. Mauritania has also expressed an interest in mining for rare earth metals in Antarctica, in line with the idea of the common heritage of mankind, which is defined by the UNCLOS and frequently applied to the areas beyond national jurisdiction, such as the high seas and the moon. Essentially, this means that states have agreed not to stake a claim on any minerals located beyond the areas of national jurisdiction. Antarctica, in contrast, is generally considered to be an international space which can be used by all states for the purpose of international peace and science activities. Although there are currently 7 claims on Antarctic territory, the Antarctic Treaty puts these claims on hold to prevent any state commercially developing Antarctica. Commencement of mining based on the common heritage of mankind idea would be flawed, although scientific research such as taking core samples remains a protected activity under the Antarctic Treaty and the UNCLOS. However, certain criteria must first be met, which includes information exchange and notification to other parties of proposed activities which have not yet occurred. But that said, Mauritania is not a signatory to the Madrid Protocol, which specifically addresses mining in Antarctica, requiring strict environmental impact assessments, and has a prohibition on mining for 50 years. Should Mauritania dispute the sovereignty of Heard and McDonald Islands, Australia would be in a good position to defend their claim, having inherited the islands from the British by cessation. However, Mauritania could mount a claim that the British did not in fact own the islands when they declared ownership in 1910, and as such Australia's claim is void. In terms of the Antarctic continent, the Australian Antarctic Territory is recognised by several states, but ownership was put on hold by the Antarctic Treaty. As such, no party to the Antarctic Treaty could move forward with a jurisdictional claim. Nevertheless, it is possible that Mauritania may withdraw from the Antarctic Treaty to lodge a claim on East Antarctica. The potential actions by Mauritania to take ownership of the Heard and McDonald Islands and declared Australian Antarctic Territory would be highly problematic. Nevertheless, there are ways forward to resolve this current and future disputes. First, it's recommended that Australia aims to work cooperatively with Mauritania in respect to the issues outlined in this presentation. This will go a long way to ensuring both parties meet their obligations under international law. As the UN Charter aims to ensure worldwide peace and security, develop friendly relations among states, and harmonise actions to accomplish common goals, this should be Australia's primary goal when engaging with Mauritania. If disputes cannot be successfully resolved, the disagreement can be referred to the International Court of Justice or the International Tribunal for the Lord of the Sea for any jurisdictional disputes. Secondly, it is recommended that all parties to the Antarctic Treaty System, including Australia, engage with Mauritania with view to the accession to the other treaties comprising the Antarctic Treaty System as soon as possible. Nevertheless, we do need to remember that the Madrid Protocol contains clauses which allow the ban on mining to be overturned by a consensus, and that the CCAS still allows sealing for scientific purposes. We just don't want another scientific whaling excuse on our hands, as Japan currently uses to justify its activities. As a signatory to the CAMLA, Australia is obliged to notify the Commission of any activity which comes to its attention, which should be undertaken swiftly to ensure Australia meets its obligations. This is even though Mauritania is not a party to this convention. But as a preliminary step in assessing the level of threat Australian Antarctic interests face, it is recommended that Australia takes advantage of Article 7 of the Antarctic Treaty, which allows each party to designate observers to carry out inspections with complete freedom of access. This would allow Australia to seek clarification on Mauritania's objectives, whilst remaining on good terms with them. This slide provides a summary of all the statute which Australia is a party to. The three in the red are what Mauritania is a party to, and the green box demonstrates how Mauritania could join the Antarctic Treaty System by ratifying the 3 additional conventions. And here are the main references used for this presentation. Thank you.